In this video, I'll discuss 10 of the most frequently asked questions regarding the FAA's enforcement action process. Additional information can be found on our website, www.faenforcement.com. Also, check out the additional videos on the site for information you need to know if the FAA is processing enforcement action against you or trying to deny your medical certificate. The information in this video is provided for general information purposes only and should not be considered legal advice. No attorney-client relationship is intended nor created by your viewing this video. You should always consult with an attorney about your specific situation and circumstances prior to taking any formal action. Over the past 2 decades of teaching aviation law at several major universities, presentations to professional pilots, and the active practice of law for over 16 years, some basic questions have repeatedly been asked regarding the enforcement action process. I'm going to try and address many of these issues in this video. However, I strongly suggest you also view the video, the 10 questions you should ask if you're being investigated by the FAA. View this video in order to more fully understand the enforcement action process. Let's go ahead and get started. You've received something called a letter of investigation from the FAA. What does this mean? Unfortunately, it means the FAA has already opened a formal investigation on you and has completed most, if not all of it. The FAA utilizes a computerized system to produce what's called an Enforcement Investigation Report, or EIR. By this time, they've already decided to process charges against you and are asking you to respond to the letter. What's the difference between a certificate action and a warning notice or letter of correction? FAA enforcement actions are one of two types: legal enforcement actions or administrative enforcement actions. They are very different. Certificate actions, also known as legal enforcement actions, are much more serious. They take the form of revocation, suspension, or monetary penalties, which will remain on your record for 5 years. With legal enforcement actions, airmen do have extensive appellate rights. However, the deck is still stacked against you due to regulations and current case law interpretations. Administrative actions take the form of letters of correction or warning notices, which stay on your record for 2 years. With these, you have no appeal rights. However, the FAA is not suspending your flying privileges. Any FAA enforcement action, regardless of type, may damage your reputation and negatively affect your career or aviation business. What's an informal conference? An informal conference is a chance to discuss your case with the FAA attorney and FSDO inspector. The FAA says it's an opportunity for the alleged violator to bring to the FAA's attention information favorable to the airman. You will be offered the chance for an informal conference in conjunction with the notice of proposed certificate action, or if you're a business, a notice of proposed civil penalty action. Keep in mind, the FAA has already completed an enforcement investigative report by this time. That means they've already decided to proceed with a legal, not administrative action against you. The word informal is more than a little misleading. During these procedures, an enforcement action sometimes can resolve the issues between the parties. Settlements may reflect a lower civil penalty amount. Sometimes the charges are actually dropped, or the payment of a civil penalty without a violation establishes a matter of record. There is a very real danger of attending and participating in an informal conference, as anything you say at the informal conference can be used against you in later proceedings if the matter does not settle. How will you know if the FAA is investigating you for an enforcement action? If the center, approach control, or tower controller asks you to call an FAA facility, the odds are that the FAA thinks you've done something wrong. Air traffic controllers are supposed to advise pilots that a possible infraction occurred by using the specific phraseology, possible pilot deviation, advise you contact the facility involved with a phone number. However, anytime you're asked to call a facility, regardless of phraseology, you're likely suspected of a rules violation. The terminology possible pilot deviation is simply air traffic controller lingo for possible enforcement action. Many times you won't know of a possible investigation until you receive a letter of investigation from the FAA. At this time, the EIR has already been prepared and the investigation more than likely concluded. Should you file a NASA report? With some notable exceptions explained in further detail in the 10 questions you should ask video, yes. In cases other than the ones where you are notified by air traffic controllers, you may not have advance notice, and the rules require that the NASA report is filed within 10 days of the alleged incident. What if you don't answer the FAA's LOI and subsequent notice of proposed certificate action, or in the case of a business, notice of proposed civil penalty? Well, your certificate will be summarily and immediately suspended, and you'll lose your right to fly or operate your aviation business. In addition, willful noncompliance will be looked at by the FAA as a non-compliant attitude, almost always resulting in a worse outcome than if in fact you did answer. How does FAA determine what penalty to assess you? In 2005, the FAA adopted something called an Enforcement Decision Tool, or EDT. The Enforcement Decision Tool is an analytical system used by FAA inspectors to assist in determining the appropriate recommended action for suspected violation of the FARs. The EDT was developed for the avowed purpose of matching the safety risk posed by an alleged act with the type of conduct involved. Once the FAA has the data from this matrix, they use a table of penalties in order to decide what type of penalty to impose. Should you talk to the air traffic control facility or air traffic supervisor when you're asked to call? You should always call when asked. However, you need to be very guarded in what you say, as your communications will always be recorded and possibly used against you at a later date. In today's environment, the FAA will be able to determine in almost every case who was piloting an aircraft. All voice and data tapes are retained, as well as flight plan information. If the FAA facility asks you to call has your full call sign, or can determine it from other sources, they will be able to determine who you are. In some instances, the FAA will simply engage a pilot in order to educate them. However, if you're being asked to call because you're involved in a close call with another aircraft, protected airspace violation, or any other egregious activity, you will not be able to talk the FAA supervisor out of forwarding information to the FSDO. If you do call, always be honest. Yet, if you sense the situation is not one where the controller is trying to educate you, and is simply collecting data, including information like your pilot certificate number, be polite, yet refuse to answer specific questions. Something in the nature of, I'd love to answer your questions, yet I need some time to think about the situation so I can give you actual facts and not speculation, should work. Be very guarded in giving anything but very basic, non-fact specific information to the FAA. What documents do you have to give the FAA on demand? Well, the FARs require you present your pilot certificate, medical certificate, and aircraft airworthiness certificate to the FAA, NTSB, or any local, state, or federal law enforcement official when asked. That means you're required to possess them while flying. In addition, if you're a student pilot on a cross-country trip, you're required to have possession of your logbook. Otherwise, it's not necessary to have your actual logbook in your physical possession. In fact, unless you are a student pilot, it's a good idea to not have your actual logbook in your possession. The FAA is entitled to review your documents, not keep them. Do you really need an attorney when dealing with the FAA? I guess this is probably the most difficult question to answer because it really depends on your individual circumstances. I've written many publications regarding aviation. I'd love to give you a free booklet dedicated to specific issues you really need to know regarding the FAA's Enforcement Action Program and the process. Much of the material in the booklet is related to the information provided in my college textbook, Aviation Law. However, it's been greatly trimmed down and summarized for your use. I suggest you download the information for your immediate use if you're being suspected of a violation, or you can copy it and keep it in case you do, unfortunately, become subject to an enforcement action. Along with helpful information, it has several easy-to-follow charts regarding the regular as well as emergency enforcement action process. In addition, we've created a series of videos dealing with the enforcement action process. They provide answers to the most frequently asked questions regarding the enforcement process, and as I stated before, most importantly, the 10 questions you should ask regarding the process. In order to get the booklet or videos, you simply need to ask for them. Go to our website, click on the links at our site, and you'll have immediate access to this important information. We've discussed just a few of the many questions you may have regarding the FAA's enforcement action process. Our goal is simple: reliable representation that works. Our team of aviation professionals is uniquely positioned to help you. We handle enforcement action in accident cases nationwide. Enjoy our website and contact us immediately if you have any further questions.